This House is in session. Minutes of the meeting held on Tuesday, July 4th, 2023 to be confirmed. Honourable Leader, Government Business.
Thank you, Mr. Speaker. I beg to move that the aforesaid minutes be confirmed.
Questions that the aforementioned minutes be confirmed. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. The aforementioned minutes are hereby confirmed.
Announcements by Your Honour. Messages from Her Excellency the President. Petitions, papers.
Honourable Leader, Government Business.
Thank you, Mr. Speaker. I'm commanded to lead the annual report and audited financial statement of the Caves of Barbados Limited for the year ended March 31st, 2022, as well as the annual report and audited financial statements of the Barbados Conference Services Limited for the year ended March 31st, 2022. I'm also commanded to lay the non-reimbursable investment financing agreement GRTFM 1968-8 BA, strengthening institutional and technical capacity for Barbados to meet the transparency requirements for the Paris Agreement with the Inter-American Development Bank.
Government notices. Private members' notices. Notices of questions. Reports from select committees. First reading of bills. Statements by ministers. Congratulatory and obituary speeches. Personal explanations. Motions for leave of absence. Oral replies to questions. Notices of motions for adjournment of the House on matters of urgent public importance. Orders of the day.
Honourable Leader, Government Business.
Mr. Speaker, I beg to move the suspension of standing orders 6, 16, 18, 20, 42 subsection 5, 43, and 44 for the remainder of the day's sitting.
The question that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it. The aforementioned standing orders are hereby suspended for the remainder of the day's sitting.
Order number 7, sir. Order number 7 in the name of the, the Honourable Attorney General and Minister of Legal Affairs to move the second reading of the Supreme Court of Judicature Amendment Bill 2023.
Honourable Member St. Joseph.
Thank you very much, Mr. Speaker. We are in this chamber today to make some amendments to the Supreme Court of Judicature Act, which, though in themselves may appear modest, or at least one of them certain to appear modest, but will have a significant ramification in relation to the criminal justice system in Barbados. For the benefit, Mr. Speaker, of my colleagues, I state the obvious. A Supreme Court made up of judges of the High Court has its judicial being arising out of a Supreme Court of Judicature Act. And this act, Mr. Speaker, will establish a whole variety of things. More recently, it was amended to deal with how we appoint judges. It deals with the powers that some judges have. And while I believe there's a public perception that judges can do anything, the simple fact is that as they carry out their responsibility, they too are governed by rules. The specific amendment that we are making today, and I'll read it for the benefit of the public. The Chief Justice, this is what we propose to insert. The Chief Justice may make practice directions in respect of criminal matters, and by practice direction, issue sentencing guidelines for the guidance of judges in the trial of criminal cases, and judges shall comply with those guidelines. In essence, therefore, Mr. Speaker, we are attempting to clothe our judicial officers with a specific power. And the hierarchy of this power is that the Chief Justice will be given the power to make guidelines for sentencing. And when those guidelines for sentencing in criminal matters are issued by the Chief Justice, they are then to be followed by our judges. Mr. Speaker, one of the things that we have had occasion to say repeatedly, both in and out of this chamber, is that we respect the concept of judicial independence. Now, people will have a view on whether what a particular judge does in a particular instance is right or wrong, is reasonable or unreasonable. That is their entitlement. But the one thing that this administration, and I believe all previous administrations, have held fast to is that we must follow the rule of law. I was very heartened to see that Barbados ranks, I believe it is 7th on a rule of law index that was issued recently by an international agency. And part of the rule of law says that the executive and the parliament need to keep out of matters that are within the discretion of judges. And that includes matters relating to sentencing. We have our views, we see the news reports in the paper, and we will wonder, well, how come so-and-so got a slap on the wrist? How come another person had the book thrown at them? Why wasn't a particular kind of sentence imposed? We say that person want locking up. I don't know how the judge could let him out. But, sir, we follow the rule of law that says that we cannot interfere in any way with the discretion of the judges. Now, some people will say, but that don't make sense because there are a lot of laws that say if you commit an offense, you shall be fined X. You shall be liable to Y term of imprisonment. Let me take the opportunity to explain this, sir. While a statute can say what fine or what term of imprisonment an individual is liable to, under our Interpretation Act, it says clearly that such a stipulation represents the ceiling. It represents the maximum that a judicial officer can impose. And he therefore has the discretion to impose any lower sentence or any lower fine. And this matter came up for consideration in many places. It came up for consideration in our High Court in a number of instances where individuals were sent to the psychiatric hospital until Her Majesty's pleasure is known. And that has been ruled to be unconstitutional. We had the recent decisions, the recent decision of Nerve and Sensimilia against the Queen, as it then was, where the mandatory death penalty was found to be unconstitutional because it robbed the judge of the discretion to determine what sentence is appropriate or would be appropriate in a particular case. So even, sir, in situations where as a legislature, there have been efforts in the law to circumscribe the powers of the judge, those efforts have been repeatedly found to be unconstitutional. So our death penalty, Mr. Speaker, is no longer mandatory. And I don't mind sparing a moment this morning to reiterate that. People say, oh, and we ain't got no more death penalty. We do. But what existed as law before the Nerve case was that where a person was found guilty of murder, they had to be sentenced to death. The judge could not take into account mitigating factors. He could not take into account a whole variety of things. It was all or nothing. In fact, Mr. Speaker, that is why you called it capital punishment. There was nothing else. But so strong has the move towards judicial independence been, so strong has the need to protect the powers of a judge grown, that our law now says that judges must have full discretion. But the law also recognizes that some things are like an unruly horse, and you don't know where they will end up when once they have started. There are times, Mr. Speaker, when I'm sure you in your busy criminal practice might have been dumbfounded at a particular sentence imposed by some judge. I hope it would not have happened too often, but I have no doubt that you would have been. Because as a society, we call out for rationality in all matters relating to the rights and privileges of individuals. We call out for consistency of approach. We call out for predictability. But all of this can perhaps be subsumed into one word, sir, that we call out for fairness. And I apologize to the chaplain if I sound a little sacerdotal this morning. I don't plan on coming to his congregation and delivering a sermon. But that is what it is, sir. It is about fairness, and fairness is characterized by an evenness of treatment in all circumstances. And therefore, if one person is sentenced to a higher penalty or to a higher term of imprisonment for the same offense, then almost instinctively we ask ourselves, is it fair? We as lawyers will ask if it's rational, we use a lot of fancy words, but it has to be fair. But bearing in mind, sir, that we have to give judges the full power to exercise their discretion, the methodology that we propose to adopt in Barbados, Mr. Speaker, is one where the Chief Justice will prescribe sentencing guidelines. And the mere use of the word guidelines will indicate that a judge, while he is expected to follow the methodology set out in a guideline, he is free to go on either side of it. Now, the guidelines, Mr. Speaker, do not stipulate for an offense of robbery where the fine is supposed to be X, you should give Y. It doesn't get into that detail. What it does is it says, for a particular kind of offense, this is the way a judge should approach the matter of sentencing. And sir, it can give you a quick idea of some of the factors that are considered or that are considered in sentencing. And I will say to the chamber that these have largely arisen out of case law, but also out of common sense. So there are certain general principles that relate to sentencing. And the first one is that every sentence that is imposed must be clearly expressed, and the reasoning for imposing a particular sentence is given. That serves two purposes, sir. By clearly expressing it, there's certainty, and by giving reasons, it allows not just the public, but any court of appeal to measure the fairness of the sentence that has been imposed in particular circumstances. I have been in some courts, sir, where, but this is of course a long time ago, where judges have pronounced a particular sentence, and you have no idea how to arrive at it. It is almost as if they had figures in a plastic bag and they're pushing the hand like a lucky dip. And pull out one and this is it. You simply couldn't follow any process that would allow the members of the public, the practitioners of law, the accused, to understand why this particular number, why was I sentenced to this particular thing. But when you are required to give reasons, then that allows in the measurement of the sentence. So there's a list of factors that are to be considered by judges, and it's not an exhaustive list. So you get credit for an early guilty plea. By now, I think every Barbadian who reads the crime pages sees this in operation every day. Because as the courts, as the reports of the cases are given, they will see the judge say, well, I taken off something for an early guilty plea. You're not wasting the court's time. So thank you for that. And we take off a year, 2 years, whatever it is. They say in the sentencing guidelines that an early guilty plea is in the public interest and should attract a credit of 1/3. So if you plead guilty early, you know, well, there's no guarantee, because there may be other aggravating factors that may cause a judge not to give you the 1/3. But if those other aggravating factors are not there, then you will get the benefit of a 1/3 discount. Other factors that are considered would be whether the individual has a large number of charges, for example. So if you have a large number of charges, if you are a serial offender, then the court looks at the principle of totality. I'm not going into this in great detail. Good character is one that is always taken into account, and therefore bad character must also be taken into account. Whether there's a particular element of dangerousness associated with it, whether you've assisted the prosecuting authorities, delay can also be a mitigating factor. So the point is, this does not say impose a fine of this or impose a penalty of this, but it does say if these particular circumstances that are beneficial to the overall criminal justice system appear, then there's a system of discounting that would apply. But on the other hand, if there are personal circumstances that militate against that benefit, that say this individual is such a vagabond, I'm not going to give him a discount, then you don't give the discount. But it is always in the discretion of the court. Now, sir, one of the things that we have noticed is that in a situation where an individual has a reasonably good idea of what penalty is going to be imposed, he or she is more inclined to enter a guilty plea if they are in fact guilty. I've said to you, for example, that an early guilty plea, you immediately get a discount, a recommended discount of 1/3 of the sentence off. So an accused person who, and unfortunately there are many people like this, sir, finds himself languishing in our prison system without bail and has committed an offense, he may say to himself, well, I can fight this case, and there's the attendant cost, there's the attendant delay, there's the unpredictability of the jury, there's even the unpredictability of the judge. I can factor in those things and decide to fight it, or I can say, when I look at all of these factors, these things apply to me, and they suggest that certain discounts should be given. So if I plead guilty, I know I'm going to get 4 years. On the other hand, if I don't plead guilty and push this court through to the end, I might end up with 12 years. And so an individual, now I'm not suggesting at all, Mr. Speaker, that an individual who is innocent of an offense should ever plead guilty. I'm not suggesting that. But I am saying that it allows a person who is accused and who is satisfied in himself that he is guilty can make an informed decision about how to proceed. And we know, sir, that there are individuals, and it is regretted that the system is not yet brought under control, Mr. Speaker, but we are working on it and we are getting there. And I'll come back to that in a minute. But there are individuals in prison who want to plead guilty. But the system as it is has been dragging and dragging and dragging and dragging for years. And I am aware, as you are, Mr. Speaker, that there are some people who will apply for bail. Not that they expect to get bail or they want bail. What they really want is a chance to get before a judge, to say, Judge, I don't want to waste more time with this. I really want to plead guilty. Like this bail application, I'm not interested in this. I just need to get before a judge so I can plead guilty and get this thing behind me. We believe, Mr. Speaker, and evidence has shown that in circumstances where the kind of penalty that might be imposed is reasonably predictable by an accused person, then that is a strong incentive for the individual to plead guilty. I read with great interest the comments of a particular judge in today's paper. I don't think he knew we were doing this amendment today. I certainly didn't know what he was going to say. But I think the essence of it is that to get a matter disposed of, however it is, whether through guilty plea, whether through withdrawal of charges, it helps to ease the backlog that is choking our judicial system. Now, Mr. Speaker, I believe that as a government we have a proud record that will stand the test of time when history looks back at how we dealt with the matter of the criminal justice system in Barbados, of which sentencing is a small part. Mr. Speaker, I remind the members of this chamber that when we came to government in 2018, we came to government having stood on a platform of correcting the ills of a judicial system that was failing us. We spoke about it every night on our platforms. We included significant commitments in our manifesto. And we came to government, Mr. Speaker, and found that there were only, well, not being found, because we knew it to be so. We came to government at a time when there were only 2 High Court judges doing criminal matters. And because of the system of rotation, Mr. Speaker, you well know that those 2 High Court judges could be doing criminal matters now, and come September, you hear so-and-so off the bench, they're going to civil court, and somebody else now come. No, sir. All of our judges are good judges. But all of our judges aren't necessarily good criminal judges or good civil judges. But because of how our system had evolved, we did not have a concentrated body of individuals who worked exclusively in the criminal system. So you had 2 judges, but they could be rotated. I remind you, Mr. Speaker, that we came in and we resolved that we were going to increase the number of judges doing criminal matters to 5. And to my great pride, I say, sir, that we didn't just pick and choose anybody. We also decided that the method of the selection of judges in Barbados needed to be reformed, and we adopted the Latimer House principles and amended this very act, sir, to establish something called a Judicial Appointments Committee. That's the second part of the amendment. And that Judicial Appointments Committee set about reaching out across the entire Commonwealth, asking people to apply for vacancies in our judicial system. And the rest was history, sir. That committee has done a marvelous job on the 2 occasions that it has functioned, and it will be functioning again shortly, but I'll come to that in a few minutes. So we changed how our judges are appointed so that the system is transparent and fair, but we also increased the number of judges from 2, sir, to 5. More than double it. Mr. Speaker, in the last 12 months, we went even further. And we said that those 5 judges that were dedicated criminal court judges, we wanted those 5 judges just to do murders and to make sure that we didn't run into a state of backlog in relation to other matters. We appointed a further 3 high court judges to the courts of Barbados. So within under 5 years, Mr. Speaker, we moved from having just 2 to 8 judges doing criminal matters. I will wait for you, Mr. Speaker, to tell me if, in your unbiased professional view, the system has been working. But I believe, sir, though it is not perfect, though it will never be perfect, that by having this dedicated number of judges, we are beginning to see the backlog come down. We're beginning to see it come down, sir. It should go without saying that the existence of COVID prevented jury trials from taking place for a 2-year period. And that obviously complicated our ability to bring down the backlog in the way in which we would have liked to. But we've passed that. We've increased the number of judges, and those judges, Mr. Speaker, are working. When we add this initiative, it will allow for those sentencing guidelines to be brought into law. It will remove much of the uncertainty. Judges will have the added burden of giving reasons, but the truth is they've known that they've had to give reasons. We're just codifying it now. And we believe that the system will be a fairer system. Mr. Speaker, the sentencing guidelines will be issued in 5 basic categories. But the general principles which are going to be set out will apply to all criminal matters. So the guidelines, as I said, you will have a general guideline which will apply to all criminal matters, whatever kind it is. But then there are going to be specific guidelines issued in 5 general areas. One, and I'll set these out now, sir. Causing death by dangerous driving will have its own guideline. Drug offenses, which will run from smallest to the largest. But just to throw in a little thing, sir, you recall that by making the amendment to the Drug Abuse Prevention and Control Act, we have effectively cut away from our entire system the offense of possession, as it was, in relation to small amounts. But I don't want to confuse the system, because you and I both know that those are magistrates' court matters and not high court. And what we're dealing with here are high court. But I apologize for the little, we have to pat ourselves on the back every now and again when we can. So drug offenses will also have its own guideline. Firearm offenses, Mr. Speaker, one of it is perhaps the bane of our modern existence. Now, Mr. Speaker, we have a licensed gun regime in Barbados. And individuals can apply for a firearm license. We made some amendments to the legislation last year. If the police turn them down, then they can appeal. But we have a system of licensed firearms. But we're talking here about illegal firearms, sir. And you know what that is about. You know well that there's a criminal element out there that considers the possession of an illegal firearm as being important to the protection of their criminal enterprise. They consider it to be important for the protection of themselves, and they consider it to be important for the carrying out of elements of their criminal enterprises, whether it is threatening people or shooting people. We have, Mr. Speaker, I think the number is just shy of 300, but in my wrap-up, I do have the correct figure, but my screen has timed out and gone blank, so in my wrap-up, I'll be sure to give the Chamber the precise number, but it is in the high 200s of firearm offenses, and I'm not talking about homicide by firearm, just firearm offenses simpliciter that are waiting to be dealt with in the system. Sentencing guideline is perfect for that. And then, Mr. Speaker, the other area, the fourth area that will benefit from guidelines, offenses of dishonesty. And the offense of dishonesty come now into 4 categories: theft, robbery, burglary, and aggravated burglary. And then the final specific area that will benefit from a guideline will be rape. So as I said, the scheme that is proposed will be a set of general guidelines which sets out in relation to any criminal offense, these are the kind of matters you consider: aggravating, non-aggravating, beneficial to the accused. It's a whole set of them, and this is how you approach it. But then we have specific guidelines which go into the detail of the factors. Now, sir, this is not a situation where Barbados is alone. Sentencing guidelines are seen as being an important part of a criminal justice system and are adopted almost across the entire common law system. Adopted in England, adopted in Canada, all throughout the Commonwealth. And Barbados is coming to this particular game a little late in the day, sir, because all across the OECS and so on, there are sentencing guidelines that are applicable. But in this case, Mr. Speaker, better late, of course, than never. Now, as I said, sir, the Chief Justice did not have and does not have the judicial authority to issue sentencing guidelines for criminal matters. He has the undoubted power in relation to civil matters. So this amendment is to give him that power in relation to criminal matters. Now, Mr. Speaker, by way of a few general themes, there are a few other things that I want to use this opportunity to speak on. We have recently had a 2-day seminar on the reform of the criminal justice system. And there are a number, sir, this had input from all of the stakeholders in Barbados. We met first at the Lloyd Erskine Sandyford Conference Center. Then our second session was at the Hilton. Completely subscribed. In fact, I wish we had more room for more people. And all of the stakeholders sat down together for this 2-day period and looked at our criminal justice system and tried to reach a consensus on those things that would contribute to the system in a beneficial way and reduce the backlog and so on. A number of things have been put on the table. We've had an important study done that was presented to all of the participants. And some of those things, sir, would be such things as plea bargaining legislation. We agreed, the entire body, the entire list of individuals who participated in those seminars, agreed that a plea bargaining system would be useful to Barbados. That legislation, Mr. Speaker, has been drafted and has this week been sent out to all of the stakeholders for their comment. Now, sir, we had this seminar, I believe it was in May. And in July, I'm telling you that we've completed the drafting of one of the pillars, the plea bargaining, and it has gone up for consultation. Within the next week or so, I expect that the other initiative, which deals with judge-alone trials, something that is novel but we feel important, that draft legislation would also be completed and sent out to stakeholders for discussion. What we've tried to focus on, Mr. Speaker, is the simple question of what are those steps that we can take that will allow our criminal justice system to work at its optimum level. And at its optimum, what we would expect to see, Mr. Speaker, would be that the backlog in criminal matters will be significantly diminished. People's cases will go through the system quickly. The maxim of justice delayed is justice denied must always be held, sir, as the centerpiece of how we do things in this country. And it was an important consultation. In fact, sir, let me go backwards a bit. These sentencing guidelines that we are proposing are not things that were hatched up in the mind of the Chief Justice. We drew on the experience of the other jurisdictions that have sentencing guidelines. We see what they have. We see how our courts have viewed particular things. But then, Mr. Speaker, we had a public consultation in Barbados. So we went to the Barbadian public and asked them, what do you think of these guidelines and how we propose to approach the matter of sentencing? Sir, we don't sentence chairs. We don't sentence rabbits. We don't sentence cars. We're sentencing people. People who have run afoul of the law and injured other people one way or another. So you have to take into account the rights of the individual accused, but you also have to take into account the person who has suffered injury. So it was important to have that consultation with the public of Barbados because at some point in time, they may have suffered injury, perhaps a brother, perhaps a child, perhaps a mother or father, perhaps themselves. And ask them the simple question, how do you feel about this approach to sentencing? If the public of Barbados did not have a sense that it was fair, sir, then this particular process would be doomed to failure from the start. So we made sure and had an important consultation so that the guidelines and the general principles, when promulgated, sir, we can put them out there knowing that the Barbadian public has been consulted and their views taken into account. But to come back, sir, to the whole thing of the criminal justice reform system, there are other initiatives that we're looking at taking. Some of them are shorter term, some of them are going to be longer term. One of the recommendations was that we get rid of the system that currently arises where indictable matters, they're not called indictable matters anymore, but we can use that term, we don't call them arrestable offenses, but we can use that term so you understand. I think that's a concept that people have an inkling of. As our system stands, while we don't have preliminary inquiries the way they used to be, where you used to have a mini trial to see if there's a prima facie case, we moved away from that. We got rid of that under the dependency of the then Chief Justice, Sir David Simmons. But now we're looking to go even further by removing that intermediate step altogether. So that when you are charged and the file goes to the DPP, it is either going to trial or not going to trial. You get rid of that intermediate step. That intermediate step takes time and it costs money. Now I have to say, as a young lawyer, preliminary inquiries were liked because it meant you had two bites at the cherry. You could try to get them off at the preliminary inquiry with all kinds of motions and so on. And if you get them off there, good for you. But if you didn't get them off there, at least you know what the defense case was, what the prosecution's case was, and you wait for them and took another bite of the cherry at the trial. But these things clog up the system because it ties up the time of a magistrate who also has thousands of cases to hear. So removing this intermediate step, which the current view says is largely unnecessary, will help us, sir. It'll move cases through the system a lot faster, but it will help to get rid of some of the clogging, some of the delays that individuals currently experience in the system. The other thing, and it may seem, I'm going to finish soon, but I think it's important to mention how we care for witnesses. Without a witness, sir, there's no case. And our system is almost characterized by a police officer taking a statement from a person who might have suffered the injury or might be a witness, and then nothing. Nobody says to them, this is what you can expect to happen. This is the time frame within which you can expect it to happen. When you do get called to go to court, we will try to give you at least a week notice. Mr. Speaker, how many times do you know that people, a bailiff shows up the night before and says to somebody, early morning, and says, case coming on today. You gotta get to the Supreme Court at 9 o'clock. You don't even remember the details of what you said back in 1994 when the offense took place. And they call you then. They have no regard for what you have to do. Case coming on, come court. Nobody even tells you which court you're going before. They just say, come court. There are some individuals who don't know if they have to bring their own lawyer to court. You got to tell them, no, you don't need a lawyer. You are giving evidence. Nobody explains to them that a particular defense lawyer is going to be brutal with you because he is client on the line. So our history, sir, is one where nobody invests in the idea of caring for the individuals who have to give evidence. So a number of things happen. They forget because nobody reminds them of anything. And there are instances, Mr. Speaker, where they go away. They've taken their annual holiday. Maybe they're planning to go away. So one of the initiatives that we want to bring into place, it may not seem like a bread and butter issue, but is vital to the lubricating of our criminal justice system, because if we do not treat witnesses and potential witnesses with respect and civility, we're not going to get the best out of them. There are instances, sir, where rape victims especially, they get notice they got to come court late. They don't know what to do. They don't know what to expect. No, sir, to be fair, this is not an indictment on my own staff at the Office of the DPP. They do the best they can. But they do it not because the system builds it in, but because they have a vested interest in having a successful outcome. And we're saying, Mr. Speaker, that the system has to build it in. And we've begun some discussions with the Minister of Home Affairs, who also has responsibility for information. And we've begun the discussion on how can we effectively communicate across the board to individuals. Witnesses are important, and we've begun that. That public outreach program has started. But we also have to tell them that we care about your role in this process. And we're looking to produce various information pieces so that individuals will be comfortable at the role they have to play in the judicial system. Some individuals believe, Mr. Speaker, that they'll be at risk if they come to court and give evidence. They believe that. Now, it may, in some instances, be irrational, but in other instances, it may be quite a legitimate concern. And we don't have a witness protection program in Barbados. Barbados is too small for it. And we've talked across the region as a body about having a regional witness protection program, but this is new to us, sir, and the financial burden of that is one that it is not one that we're able to bear easily. I think if you look at some of the Trinidadian newspapers, you would see that there are instances where Trinidadian witnesses are in witness protection. And at Carnival, they come out of witness protection to go to a fete. And that's the last mass, because they get shot down at the fete. These are things that happen. But, you know, we can't disabuse ourselves of the idea that there are witnesses in Barbados who feel that they have to be protected, that they have to be cared for. Now, Mr. Speaker, I believe that I'm probably venturing a little far in this debate. Let me, as I move towards wrapping up, just say one thing of general public interest. Mr. Speaker, we are now in the middle of our crop over season. It has largely been incident-free. It has largely been incident-free. We've had one very well-publicized, outrageous example of how Barbadians can behave. And I refer to that storming of the particular entertainment venue that took place about 2 or so weeks ago. We went through COVID, Mr. Speaker, and all through COVID, we spoke about what it meant to be a Barbadian. This is who we are, was the tagline from that very popular song. But COVID is finished now, so some people seem to forget the concept of what a Barbadian is and who we are. Let me say that we will have zero tolerance for anybody or any group of people who believe that they can disrupt the Barbadian way of life, whether it has to do with fetting or whether it has to do with going to church. Individuals, I have to be careful how I say it. Individuals save for crop over sometimes in ways that they don't save for many things. Individuals invest in crop over. It is the occasion of their release, perhaps. It is an important festival for Barbados. It is an important occasion for the individuals who choose to participate in it. We have families whose livelihood depends on a successful crop over, sir. How dare a bunch of hooligans believe that it is right for them to disturb the merriment of individuals who come out just to party in an environment of peace and safety? Mr. Speaker, I don't want to make this into more than it is, but the fools who believe that they got away with it, and they haven't, but they feel that they got away with it, and the fools who saw it and may feel, boy, next fete, man, let a group of it try that too. They have another thing coming, Mr. Speaker. The police service of Barbados is on its guard. Mr. Speaker, I expect that the Commissioner of Police in the next day or so will be doing his usual pre-Krapover press statement to say to the public as best they can how this Krapover season is going to be policed. I have had my briefing from the Commissioner, and I can assure those individuals who want nothing more than to have an enjoyable season, and I can assure those individuals who somehow or another feel that they can be able to come and disrupt it, that the members of the police service are on their guard. They'll be using every element of modern technology that is available. This is not something that we either can tolerate or want to tolerate, Mr. Speaker. What happened at that event is perhaps a clarion call for all of us, sir, because we've seen the rise of indiscipline in our society. You know, Mr. Speaker, and member for the city is well able to speak about this. It's called the broken windows syndrome. And the idea is that if you look in a community and you see a few windows broken, a little bit later on you can come back and you see more windows broken. And then you will see in a progression decay setting in systematically. And the sociologists will tell us, have told us, and are telling us, you should deal with the broken windows early, so that when you see these things beginning to emerge, deal with them then, because if you don't deal with them then, that crescendo effect will be felt. So I am letting these men and women who feel that hooliganism and so on in Barbados will be allowed to affect our Krapover, not under this government's watch. They do not think about the fact that what they have done has created a problem for other facts, for other events. Insurance. Now, Mr. Speaker, let me say, it is not enough for me to chastise and caution the villains who will want to create havoc. I must also say to promoters that they have a solemn duty to their patrons to be sure that they make the appropriate investment in their own security. Mr. Speaker, the Barbados Police Service is here to protect and serve. In a limited way, they are going to be available to police events. But they still have to police Checker Hall. They still have to police Grisettes and Pori Spring and Horse Hill and Martindale's Road. The Defense Force, as we've been doing for many years, is continuing its joint activity. There's already been a meeting, there have been several meetings with the hierarchy of the NCF. I am able to say that today itself, the police and the NCF will be meeting with the promoters to discuss with them the importance of ramping up their security as they see the location as an important factor, and as they see the size of the event as an important factor. So, promoters, I'm calling on you to do all that is required to ensure the safety of your patrons. The Barbados Police Service buttressed by the efforts and staff of the BDF, buttressed by today's technology. We'll be doing our part. But it is your event, Mr. Promoter. You are the person who will have all to gain and all to lose. And therefore, as you plan your event, you have to make sure that you put the appropriate security for the appropriate event. I don't want to say too much about it, but let me assure the public of Barbados that the police service has been doing a crap job so far, and their plans for policing crop over, whether it is supporting individuals in a general, supporting promoters in a general way, whether it is supporting the NCF at its mass events, whatever it is, sir, the police service is on the job. They've been doing a great job so far. Some of us have had the benefit of going to several of the public events, and I'm able to say that we've had no major issues at any of them. And I expect that that will continue. Listen out for the briefing from the Commissioner. As I said, I expect that that will happen tomorrow, at which he will share as best as he can the details and the policing plan. So, Mr. Speaker, let me just wrap up by adverting to the other part of the amendment. The other part of the amendment, sir, seeks to allow for a public officer to be appointed by the Prime Minister as the secretary to the Judicial Appointments Committee. When we established the committee, I guess certainly at my level as AG, we knew what we were asking them to do, but what we didn't have in mind was the volume of work that it would take. When they were engaged in the process of selecting judges, we asked them to reach far and wide, go all over the Commonwealth, all throughout the Commonwealth, all throughout CARICOM, all throughout, you advertise widely. What we did not expect was the deluge of applications for people who were interested in coming to Barbados to be a judge. Many of them were not suitable, but you still had to go through the exercise of receiving, you had to look at them, you had to go through a whole set of work. And unfortunately, because we didn't make provision for the appointment of a secretary, it created some challenges for the Judicial Appointments Committee. They managed to wade through them, but they've asked that we fill this particular lacuna so that they can work more efficiently and at a faster rate as they set about the task ahead in terms of recruiting new judges. Mr. Speaker, there are going to be a number of vacancies coming up in our High Court, possibly our Court of Appeal, and I remind you that in years past, you will just hear that so-and-so is a judge, so-and-so is a judge. Those days are long past. Every Barbadian, everybody anywhere in the world will know when there's a vacancy, they can apply for it, and they go through a vetting process, they go through an interview process, they go through a shortlisting process, and this committee then recommends to the Prime Minister the individuals who they consider to be suitable for the judges, and in every instance so far, those individuals have been appointed. Mr. Speaker, I thank you for your attention. I thank the Chamber for bearing with me, probably for going on much longer than I needed to, but I hope that I've been able to give an update on some of the initiatives that we're proposing to take in relation to the criminal justice system. I'm excited about them, and I believe that before year end, I'll be able to come back to the Chamber and give a report on how these various initiatives are going. I'm obliged to you, sir.
Honourable,
Beg to move that this bill be read a second time.
Read a second.
Honourable for Christchurch East.
Mr. Speaker, I happen to have the unenviable task of speaking behind the AG, who I've known the AG, sir, for quite a while, and he is a scholar. So sometimes when he speaks or presents a bill, it leaves me with ample wiggle room to come behind in plain speak and speak in terms that other people might be able to understand. But I sat down and just listened to the Attorney General, the Honourable Attorney General presenting this, and I started to scratch off. I was going to say that, I was going to say that, I was going to say that. So I must start by commending him, sir, for an excellent and well-delivered and simple and easy-to-understand presentation of this bill. So I just want to come from a practical experience and just touch on a couple of the points. Why? Some may ask, are sentencing guidelines necessary? Why they're necessary this time? The AG explained, sir, that it's necessary to inject some certainty into the process, sir, and also to set parameters. What does that mean for the accused person? The instinct of an accused person, sir, is to plead not guilty. You very, very seldom have people coming forward and saying, I did it. You, sir, know as a lawyer that when you first get called to the bar and you start to deal with persons charged with criminal offenses, you actually think how unfair the system is because everybody is innocent. And your own clients will not tell you the full story. And your own clients will give you what they think you need to be here to be able to represent them properly. So we have a whole set of persons who are not guilty who are currently doing time, if you're to believe what is said. And quite often, sir, the refusal to confront what you have done has to do with your apprehension as to the uncertainty of what happens next. If I plead guilty to what I know that I have done, what is going to happen to me? What does that sentence actually look like? Very often, sir, if persons understand what the sentence is, it might let them actually focus their mind as to the futility of the path that they're embarked upon. If I use the easiest example, everybody knows or knew that the sentence for murder was death. You were sentenced to hang. Everybody knew it. There was no option. That was the one certain sentence that we had. So when you had a man who had a charge of murder, and he was arraigned on a charge of murder, from the time you offer him the option of pleading guilty to manslaughter, that option was taken very, very quickly. I'd rather deal with the certainty of knowing that my neck is not going to get popped and take that one off the dock. And quite often, sir, at times it was abused in the system where facts pointed to a charge of manslaughter, but the prosecution in many instances would arraign the person on murder knowing that they were going to offer manslaughter just to get them to plead guilty. It was a bit of an abuse of the process. Even sometimes when persons went through a preliminary inquiry and the charge was reduced at the PI from murder to manslaughter, it would then be reinstated as murder again just to be able to get the guilty plea. But it shows that where persons are thinking of what the maximum is, but have some idea of what the minimum is, or the parameters within which the sentence will be concentrated, it might make them more likely to accept what they've done and plead it out of the system. Now, we are never going to get on top of the backlog unless we get rid and dispose of some of the cases without trial. It is impossible for us to ever get on top of that backlog through trials only. Practically, the government needs to look at how can we fairly dispose of some of these cases or encourage the disposal of some of these cases while still securing justice for the persons who have been affected by the crimes that have been committed. There are some things, sir, that beg for plea bargaining. There are some cases that beg for the accused to just accept what they have done and get on with it. quite often as well, sir, if a man knows that he's serving a sentence for something else, and he's already in jail, and he knows if he is not certain as to what is happening in his pending charges, he may keep with the not guilty, keep with the not guilty, keep with the not guilty. That matter stays in and keeps occupying court time. It comes up every how many of days, right? A jury may get impaneled, then something happens and the case can't go on, and you keep wasting time because the matter is still there on the court's list to happen. If a man knows I'm serving 20 years or something, and he has other cases pending that, quite frankly, are not going to add up to 20 years, then he might be inclined to dispose of those once he is certain that the sentence he's getting is not going to exceed 20 years. If I put it as simply as that, you may make the mental calculation, all right, if I plead guilty to these, I'll be serving these while I'm serving the other one. And what then happens is those now come off of the court list and free up time and space for persons. The other thing, sir, is that with judicial discretion, you have to bank on all the judges exercising the same principles or not allowing their personal, let's say, prejudices, for want of a better word, to affect the decisions that they make. Sir, there was an instance, and we well know, sir, there was a particular judicial officer who, when everybody, before the decriminalization, before we had easy restrictions on possession, everybody had already moved away from convicting anybody for simple possession, If a youngster had a spliff and ended up in front of the court and he pleaded guilty, you got an R&D. Depending on what you had before, you might get some community service or something, right? But you can come out of that. You had the possibility of coming out of that with a clear record. And we know, sir, that there was one person who insisted on slapping a conviction on persons for simple possession. So there was that one person who insisted on entering a conviction where everybody else was easing the person. Also, what happens in that case? Everybody who has a possession charge in front of that particular judicial officer kept adjourning and adjourning and adjourning and adjourning until such time as that officer went on vacation. At which point, whoever was acting for that officer had a plethora of people stepping forward very quickly to get their matters brought back forward so that they could plead guilty and go on about their business. Guidelines would assist in that respect. Guidelines inject some degree of certainty. You know what you're going to get. We are now, as the AG said, we are now, sir, looking to bring in a formal system of plea bargaining. But we know it exists. Plea bargaining exists unofficially in our court system. We know sometimes the prosecution will come forward and say, look, if your man pleads guilty to this, we can work with you to get X, Y, and Z. We know it happens. But it is not within our accepted legal framework. And sometimes you have a situation, because it's not within our legal framework, you, the defense counsel, and the prosecutor might agree on something, a parameter within which to operate. You do your part and plead the man guilty. They do their part and say, well, we recommend X, Y, and Z. And the judge takes it upon his or herself to say, I'm not playing with that. And gives something outside of the contemplation of both parties. That then calls the whole issue of the reliance on your lawyer and the reliance on the word of the prosecution into question. So, the sentencing guidelines and the incoming plea bargaining regime, to my mind, sir, will go a very, very long way in encouraging the disposal of matters and allowing the accused person to make an informed choice based on the parameters with which they'll be exposed to in the sentencing. Sir, I believe quite often anecdotal, well, it's not anecdotal, but funny real-life situations actually help to make the point. We know of a judicial officer who used to come into court, especially when cricket was being played. And he would come in the morning and say, all who intend to plead guilty, go that way. All who intend to fight this case, go that way. If you plead guilty, you're looking at X. We know who that is.
Starts at 9, finishes at 10 to ensure he watches the first ball
bowled.
at Kensington Oval.
That's right. And the offer was so sweet. And it was usually with traffic. The offer was so sweet that everybody, whether you were guilty or not, you took the guilty plea, you got the slap on the wrist, and you got out. But as funny as it sounds there, all those cases were disposed of. And we moved on. If we think of how many trials are done per week in our criminal courts, we have no more judges serving the criminal jurisdiction than we've ever had before. If we look at, sir, how many cases are actually done a week, because the cases once they reach the High Court will necessarily be longer than summary cases in front of magistrate. If we look at how many cases are done per week as opposed to how many persons are arrested in a week, we know that the arrests far outweigh the amount of cases disposed of on average. So we have an issue that unless we change the way we look at things and become practical about our approach to the criminal justice system, we are forever going to be playing catch-up. Now, sir, the point was made that the civil court realizes ever since. Practice directions have been a part of the civil court regime forever. If you had situations being created that everybody accepted, there's a need for some clarity in this, that this uncertainty is causing issues with cases, is causing issues with the approach, is causing issues with the administration of justice. Then the Chief Justice always had it within his remit to give directions that will be followed in how to deal with cases, how things are served, how affidavits are witnessed. You can give your directions in relation to civil cases. But, sir, quite frankly, the process for civil and the process for criminal both occupy the court's time. And if the Chief Justice had the discretion to make rules or give practice directions in relation to civil cases, is almost, sir, an affront to common sense that some latitude should not be given in the same way to so guide criminal cases to ensure the fastest possible disposal while maintaining, sir, the integrity of our judicial system. Sir, the public of Barbados as well, we exercise in many instances a righteous indignation in relation to offenses where we don't have all the facts. Mitigation is an important part of the criminal justice process. At the end of a trial, after somebody is found guilty, your defense counsel has the right to make a plea of mitigation, at which point he will beg for you. And he will explain salient things which he wishes the judge to take into account to explain why you may have done what you did, or why, although the act occurred, there's some mental culpability. Some leniency should be exercised because all is not equal. So I do one act, sir, and the Honourable for St. Michael South does the exact same act. But if I was pushed, or if I was hungry, or if I was desperate, or if my child was in trouble or whatnot, and I did that act in pursuit of it, it's not excusing it, but it's something that must arise in the contemplation of whether to sentence me, as opposed to the Honourable for St. Michael South, who may have had none of those factors and just did it out of pure worthlessness. No, sir, that's just, only because I had to pick on somebody who's here. Worthlessness is never associated with the member for Christ Church South, sir. Me, St. Michael South. But the mitigation forms an important part. And sometimes, sir, I used to like to sit in the court and hear a person's story. Somebody that we have formed an opinion of. We have heard what has happened. You're following that the person found guilty, and you're going to hear how the lawyer begged for them. And then you hear a part of that story that you might never have contemplated. The human face is put on the person. Quite often with what is reported in the press, people get the bare bones of the facts. and the public may exercise its own opinion, but might not be seized of the facts. So it is necessary, sir, for a judge to be able to take those things into consideration in deciding the sentence. But while you want to give them the flexibility to do that, you also want to give them the parameters within which to operate and to apply their discretion, even taking into account the aggravating factors or the mitigating factors. So, having said all of that, I believe that this simple adjustment, and when we combine it with a plea bargaining regime, will go a very long way to disposing of cases, some cases that are ripe for disposal. There are a lot of old cases, sir, where the delay in prosecuting the case at whoever door that falls has prejudiced the ability to properly prosecute it. You have a victim, sir, maybe on a rape charge, a victim of rape, who has moved on with their life, who is now married and has children and does not want that case to come on. The person who committed the offense doesn't want it to come on either, because they may be out as well, or they know that if it does go through, they're looking at the heaviest possible sentence. The ability to create a framework that allows the victim to know that their case, that justice was accorded in their case, but allows the accused person the chance to just get it over and done with, knowing that there's some certainty, some framework to narrow that sentence, is going to lead to a disposal, sir, I believe, of a lot of matters. So I wish to commend the AG entirely in relation to seeing the need for us to take another step in advancing our criminal justice system. We've done a lot, as he said, in relation to the amount of criminal courts, but they can only do so much if they have to try the cases. Some cases just need to be gotten out of the system, and if it is by a guilty plea and a framework for sentencing, then let it be so. But we just need to bite that bullet and bring those numbers down. Sir, I can't end without touching as well on the matter that the AG touched on. I happen to know, sir, a number of promoters of events. And I tend to enjoy, I look forward to crop over, sir, in a way that I don't look forward to many other things. We've been on lockdown for a couple of years, and this is the first year that we actually truly outside. Everybody's hashtagging, hashtag we outside. There's an interest in the events that are going on now that didn't exist last year when people were still hedging their bets. Some people still went out wearing masks. There's an interest now, sir, in 2023 crop over that was not there for last year. One just have to go to Pandemonium on the weekend where I think the police estimate there were 30,000 people there. I happened to see the Honourable Acting Prime Minister, sir, at Pandemonium. And we were saying we've never seen that many human beings in one space in Barbados. And the thing went off quite well. So Bajans want to get back out. It is a certain element that wants to disrupt things for people, a selfish element. Back in the day, sir, when people were trying to think, and you went to a paid fete, and you were trying to get in, and you don't have the money, then you beg your friend, listen, go inside there and just get a bond off of somebody and bring that back out for me. And you try to weasel your way in. If that didn't work, you went home. You stop outside, you talk to people, somebody outside selling drinks, you hang out outside, you hear the music, but you accept it, I cannot get through that gate. We now have people, sir, who are intent and hell-bent on getting into events that they have no intention of paying for. And that is causing a problem. In addition to the highly publicized one that the AG spoke about, sir, there was an incident on Friday night. Every year there's a fete for young people. So it's persons, I think, between teenagers, teen mass, where you try to have some good entertainment for them and no alcohol being sold and whatnot. That was held at Kensington. And you had some people, some teenagers, who were intent on getting in. who were intent on getting in, that caused, without paying, that caused another issue down there. And the promoters had to call off the event. So it was supposed to run from 6 to midnight. By 8 o'clock, the thing was done because they said, you know what, we're not taking any chances. People causing the issue. Wait, we're pulling the plug on this one. We're pulling the plug on this one. Crop over is too important to Barbados. It is too important to who we are, to what we represent. It's not just Bajans that look forward to crop over. It's not just Bajans that look forward to crop over. The outside world looks forward to crop over. Those persons who selfishly want to save a couple dollars, or let me put it another way, who selfishly refuse to pay for the enjoyment that they seek, stand to do irreparable harm to our country. I agree, once again, with the AG. Security is a serious thing. If you a promoter know that you plan to make a certain amount of money, then secure your patrons, secure your event, and secure the venue. If you choose to have your fete in a big venue, you can't just secure the area that you occupy, you have to secure the entire venue. Secure your venue and not necessarily your event. Secure the entire thing. In the same way that drinks, you budget for the drinks that you order, and you budget for the food that you serve. You don't want the drinks to run out. You want everybody to have all the drinks that they want. You want everybody to have all the food that they need. Then you, the promoter, need to ensure that all the security that is necessary to make your event safe is in place. Do not cut costs on security. There are a lot of fly-by-night security operations in Barbados as well. When you go to certain events, certain established events, you will see a certain level of security there because those persons know what is at stake. Equally, if you have never heard of a security company, if somebody comes offering you security for an event, question them, ask them for the credentials, find out what they did before. The security of the persons that you choose to invite, that are paying you to come into your event, should be paramount. Their enjoyment and their security, their ability to party in a secure environment and maximize what crop over has to offer should be your concern, not just the almighty dollar. So my plea to promoters, sir, and I look around and I'm seeing a number of persons, even in here, who have been to events, who have seen the events as recently as Saturday morning at 4 o'clock in the morning, right? Who I know that I'm going to be seeing at more events. The fact is we all want to enjoy what crop over has to offer. I'm asking the patrons, be mindful of your own security. If you're somewhere and you see something happen, then take yourself out of harm's way. Do not stand up with your cell phone trying to get the best possible picture of what is collapsing, what is being broken, or what is burning around you. Be mindful of your own security. And once you are mindful of your own security and the promoters are mindful of their duty to you, then I think, sir, we're looking at perhaps the best ever crop over that we have had. So I just want to support the AG entirely on everything he has said. I note that at the public events that were put on by the NCF, we've not had any incidents, I don't believe, sir. I have been to a lot of these sweet limes. I have been to Pandemonium. Anything the NCF putting on for this season, sir, I am going to. They've pulled off some amazing events this year, and I want to big up, sir, the leadership of the NCF and all those who work at the NCF. They've kept us well informed. They've promoted their events and they've executed their events, sir, with a professionalism that is mind-blowing. It is mind-blowing. Yeah. So one thing I used to think that when government does things in the entertainment sphere, it was like poor Reiki, and they had to go outside to get the good events. Sir, a lot of the NCF events are free. They put them on for the public of Barbados, and you get top quality entertainment, top quality service, sir, in a very, very safe environment. So all who are connected with what the NCF has done so far, and the other events they're looking to do, and that includes the Barbados Police Service and those who secure them. I just want to give a big kudos. You have managed to project the positive aspect of what Kadooment is about. Don't mind a couple idiots that insist on lawlessness. As the AG said, you're going to reap what you sow, right? Go and enjoy yourself. If you can't afford the paid events, then you know what? Go to the free ones that the NCF putting on. You can enjoy yourself just as much. So, sir, having said all of that, I wish to entirely support this bill, and I look forward to working with the Office of the Attorney General and the Supreme Court, sir, to publicize any aspects of this that might help people to understand what it is we're doing and might help to reduce the backlog in the courts, and also to demystify the processes that we put in place to secure the efficiency of the judicial service and the integrity of our criminal justice system. So having said all of that, sir, I just wish to fully endorse this bill and to give it my 110% support. Thank you.
Honourable Member St. Joseph.
Mr. Speaker, I wish to thank the members of this chamber for their overwhelming support of this bill. I know that the member for Christchurch East spoke on all of their collective behalves. Mr. Speaker, I don't know that I committed to the chamber. I don't know that I have much else to say. I committed to the chamber to give the chamber specifics on the backlog of firearm offences. Just to remind that I said that one of the sets of guidelines would relate to firearm offences, and I did say then that the area of firearm offences is a major concern. So at the end of April, we had 287 firearm offences waiting trial. So these guidelines, and of course some have been added since then, but these guidelines therefore will impact 287 firearm offences, and so having discharged that obligation to the chamber to give them the full specifics, so I want to beg again that this bill be read a second time.
Beg the second.
Questions that the aforementioned bill be read a second time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
Speaker, I beg to move that you do now leave the chair and that this House resolve itself into committee for further consideration of the bill.
Beg to second that.
Questions that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
This Honourable House is now in committee.
Clause 1.
Beg to move that clause 1 stand part.
Beg to second that.
The question is that Clause 1 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 2.
Beg to move that clause 2 stands part, Mr. Chairman.
Beg to second that.
The question is that Clause 2 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 3.
Beg to move that clause 3 stand part, Mr. Chairman.
Beg to second that.
The question is that Clause 3 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do not report to His Honour the Speaker the passing of one bill in committee.
Beg to second that.
The question is that I do now report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, please say aye. Honourable members against, please say no. Methinks the ayes have it.
Chairman of committees is reporting the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
I beg to second that.
Question is that the bill be read a third time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do now pass and be cited as the Supreme Court of Judicature Amendment Act 2023.
I beg to second that as well.
The question is that the aforementioned bill be passed and so cited. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it. This bill is passed and so cited. Honorable Leader, Government Business. Honorable Leader, Government Business.
Thank you, Mr. Speaker. With that, we've come to the end of today's sitting. Rather short and brief, but we are intending to be in Parliament for the next 2 days this week. On Thursday, we will return at 2:30 in the afternoon, where we will pay tribute to the late Sir Lloyd Erskine Sandiford, 4th Prime Minister of Barbados. And we will also be returning on Friday as well to debate the integrity in public life legislation, which I'm sure, Mr. Speaker, the public will be well aware has a long history, and one certainly that we are quite excited again to be able to bring to this honourable chamber, and hopefully we will see the passage of it not only in this chamber but also in the other in due course. So with those few words, Mr. Speaker, I beg to move that this House be adjourned until Thursday, the 20th of July at 2:30 p.m.
Beg to second.
The question is that this honorable chamber be adjourned until Thursday at 2:30 p.m. All of the honorable members in favor, please say aye. Those against, please say no. We think the ayes have it. This honorable chamber stands adjourned until Thursday this week at 2:30 p.m.